Theft in Louisiana, Statute 1467. So what is theft? Theft is the misappropriation or taking of anything of value which belongs to another, either without the consent of the other to the misappropriation or taking, or by means of fraudulent conduct, practices or representations, an intent to deprive the other permanently of whatever may be the subject of the misappropriation or taking is essential. So let's look at the penalties for theft. Penalties for theft are based on the alleged amount of the taking. So for example, whoever commits the crime of theft or misappropriation taking amounts to a value of $25,000 or more shall be imprisoned at hard labor for not more than 20 years. Additionally, a fine of $50,000 or more. If the taking amounts to a value of $5,000 or more, then they're looking at not more than 10 years in prison. If the misappropriation or taking is a value of $1,000 or more, then it's still a felony at not more than 5 years in prison. However, if the alleged value is less than a value of $1,000, then it's a misdemeanor, and the potential imprisonment is not more than 6 months. Now, if the offender has been convicted of theft 2 or more times previously before the current offense, then any subsequent conviction, he's looking at a felony. It can be up to 2 years in prison. When there has been a misappropriation or taking by a number of distinct acts of the offender, the aggravate of the amount of misappropriations or taking shall determine the grade of the offense. So for example, if somebody is being accused of theft and the prosecutor saying that they committed maybe multiple counts of theft or shoplifting, the DA can add up the value of each one of those thefts to get the alleged amount of the taking. So he can make a potential misdemeanor into a felony. This is a shoplifting provision of the theft statute. In prosecution under the section where the property allegedly misappropriated or taken was held for sale by a merchant, an intent to permanently deprive the merchant of the property held for sale may be inferred when the defendant intentionally conceals on his person or otherwise goods held for sale, alters or transfers any price, transfers goods from one container or package to another, willfully causes the cash register or other sales recording device to reflect less than the actual retail price, removes any price marking with the intent to deceive the merchant. So basically messing with the price tag. When a defendant does that, then the statute says that that an intent to permanently deprive the merchant is inferred. So if you need help with any kind of criminal charge or theft, feel free to give me a call. I'm Carl Barkemeyer. I'm a criminal defense attorney. You can call me at 225-964-6720 or visit my website at attorneycarl.com. I'll be happy to help.